Hear ye, hear ye. The First District Court of Appeal is now open. All that business for this court, draw near, give attention, you shall be heard. God save the United States, and the state of Florida, its honorable court.
Be seated. Good morning and welcome to the First District Court of Appeal. We have 4 cases on the calendar today. We'll call them up in the order in which they're listed. And with that, we will call the first case, Chappell v. Roberts. Counsel for the appellant may proceed. Chappell or Chappell?
Chappell.
Chappell.
Good morning. May it please the court, James Middleton, Smith, Canberra, and Russell on behalf of the appellant, cross-athlete Mark Chappell. This case is about a 3-day bench trial in Duval County Circuit Court. After the parties were informed by Judge Day on the first day of trial, an affirmative waiver from both parties regarding the trial judge's participation with the new courthouse was received on the record by transcript page 215, volume 1, on October 28, 2009. Thereon, we completed the first day of trial, the second day of trial on October 29th, and the third day of trial on December the 30th, after providing the judge waivers that his participation with the new courthouse project served no issue of conflict for either of the parties.
Well, is it your position that if the parties waive this issue that the judge must sit, or does the judge have some say in it, irrespective of what you all agree to?
If the judge felt that way, he would have removed himself on the first day of trial. And he did complete the trial. There was never any suggestion, as noted in his order here, that's at issue, the order granting new trial at R6-1101. Early on, this court notified the parties of the court's involvement with the new courthouse project. Neither party to this action has ever suggested any question of conflict regarding this court's participation in this case, while it was also involved with the new courthouse project. However, this court, on its own, finds that with one of the parties to this action, actually an affiliated company of the party, Mark Chappell, seeking contracts related to the courthouse project, that a court not directly affiliated with the courthouse project would have been and still would be better suited to preside over this matter to avoid any appearance of conflict. And in the second page, he refers this case that it will be tried by the Honorable Lawrence Paddock of the Fourth Judicial Circuit.
So does the judge have the duty to the litigants to avoid the appearance of a conflict, or to the public at large?
He has both simultaneous duties, and in this case, the question before this court is whether or not the duty to the public at large is at all compromised in this case. The transcript is to avoid any objection by either counsel regarding this courthouse project being an issue. It was purely a collateral matter, a bench trial between 2 business partners that were essentially divorcing themselves, and we were trying 3 reserved claims that had been reserved after a settlement by Maddox Hare of the major issues in the case.
But doesn't your position put the judge in an untenable position with regard to the Code of Judicial Conduct? If the judge feels that sitting on a particular case will affect the appearance of, of an impartial trial, doesn't the judge have an obligation to recuse and not hear that case, irrespective of any compromise between the parties?
If he felt that way, yes, and that's the Code of Judicial Conduct.
And doesn't his order reflect that he felt that way, that he thought that there would be the appearance of impropriety?
He said that it says here to avoid any appearance of impropriety, not that there was impropriety, and out of an abundance of caution is what was stated in here. But the actions of the judge reflect that he did not have that feeling. He brought it clearly to our attention in the transcripts, pages 207 through 215 of the first day of trial.
So you're asking us to look beyond the judge's words and look at his actions instead?
Well, no, we look at the totality of the record here, that if this is an issue that is not reserved for appeal by the appellee here, it is a fundamental error. What the appellee must show is a palpable miscarriage of justice under Powell v. Allstate. And that is not apparent or reflected by Judge Jay's comments in the transcript, Judge Jay's order that there was a palpable miscarriage of justice, or that this litigant was denied the right to a fair trial. That would be if that error was preserved. But we are at the fundamental error stage under the Harlan Bakery's case that talks about what is required. If the issue is not preserved before the post-trial hearing, the trial court power to grant a new trial is further restricted to those exceptional errors that are fundamental. If an error is preserved, then the legal standard is whether it's so pervasive or prejudicial that the injured party is denied the right to a fair trial.
But isn't that the standard that applies when you have a motion by a party? Isn't there a different standard when the judge does it on his own motion?
Is there a different standard if the judge does it on its own motion versus whether a party raises it?
Yeah.
I'm not aware of a case that has addressed that specific point, that a judge is governed differently in granting a new trial under 1.530F than does a litigant. Can a judge raise it sua sponte? Absolutely, because they're really, normally these come up in a jury context. And if the judge felt that a jury, but here, the judge was the jury. It was a bench trial. So in that instance, I would think it's less likely that the law would find a difference because that judge was fair. And I want to reserve 5 minutes. I'm sorry I did not for the cross appeal and issues. So I'm not aware of a case that says that it's different when it's sua sponte by the judge in a bench trial. The other cases that talk about this is a question of law for this court. It's reviewed de novo as the appropriate standard because this error was not preserved, and it says here whether unpreserved error is fundamental may thus warrant new trial is reviewed as a question of law. That's the Hasegawa versus Anderson case. And in this instance, looking at the factual thing, the order says here that the bid for the new courthouse project had not even occurred at the time the order granting a new trial was entered in July of last year. So if he had ruled a year earlier and he informed the parties in December of 2010 at an ex parte hearing, the only reason he delayed was that he thought the city of Jacksonville was going to be awarding the bid contract for furniture in the new courthouse at that time, and that wasn't happening on at the speed that he expected. And then he decided that he could not wait any longer. But how that could have affected the impact of the issues that were raised in our case, the issues raised in our case were stock day trading, checks cut directly to Mr. Chappell or to third parties, and that had nothing to do with the courthouse project and the events in 2011. The project was not awarded, and there is no appearance of impropriety to the public at large demonstrated in the record here.
But you're asking us to apply an objective standard as to whether there was any appearance of conflict as opposed to a subjective standard which the judge would apply.
I am asking you to apply, yes. You all can only apply an objective standard, I believe, because a test of conscience approach that has been advanced by the appellee in this case would allow judges, trial judges all across the state of Florida, the carte blanche, decide when they want to give a new trial and they say that's within my own conscience what I decided. And Rule 1.530F is a significant rule because it requires specific grounds to be stated in granting a new trial. If they're not stated, this court relinquishes jurisdiction to make those findings.
But Judge Day did make specific findings, and again, it was the appearance of conflict with regard to the courthouse bid process. So it's not an order granted without any kind of specification.
That's correct. And in the record here, the court at pages 209 says that we plan on continuing furniture purchases for the new courthouse. It would be an extremely substantial number, probably well over $1 million. And TOS would be definitely in the running for that. And I would be one of the ones making the recommendations to the chief judge.
Well, I'd like you to discuss the Martin v. Carlton case, because in that case, we did say, on a very similar matter, that it would be difficult for this court to test the conscience of the judge. And aren't we in the same position here?
I don't think so, Your Honor, because in this case, the conscience of the court was asked by Mr. Lippis, and he asked the court, Your Honor, do you have an issue with this? And he answered directly, without hesitation, no, I do not. That is not an issue for him, and it was apparent from the trial proceedings thereafter. And when litigants, we all talk about the excessive cost of litigation, and our clients both spend time, effort, and money. Day 1 to conclude, day 2 to conclude, day 3 to conclude, post-trial submissions, and then objections to those, and then the court.
Well, that's a good point, and it is unfortunate that this happened so late in the game because of the economics of it. But on the other hand, if we were to accept your position, would we not have to essentially say that a judge is completely powerless to recuse himself or herself after a judgment and during the pendency of rehearing proceedings?
No, Your Honor, that would not be the case because of the facts of this case. Judge Day was, I think, disclosed everything, and there was never any indication in any of the transcript or the rulings that the courthouse public had anything.
What is the effect of the motions for rehearing? Both parties asked for rehearing, right?
No.
I mean, I think if you had...
Oh, yes, I did. On
You
the
did.
attorney's fees issue,
Right.
and then we resolved that attorney's fees issue.
So, I mean, I could see you have one scenario if there was a judgment, and then, a few days later the judge says, nobody said anything about it, but I'm feeling funny about this, I'm going to recuse myself. But there was a pending motion for rehearing by both parties. There was litigation before the court at the time the judge recused himself.
Yes, mine was resolved by the time that he entered his order granting new trial, because we stipulated and resolved the attorney's fees issue that worked its way into the order granting new trial. But the other issue, the 47-paragraph amended motion for new trial, is silent on any issue dealing with a conflict of interest. That's not the issue in this case, and I'll reserve the rest of the meeting.
Counsel, you have a cross appeal, and so you would have the right to have rebuttal on the cross appeal.
Certainly.
But if you choose to do that, your comments will be limited to the cross appeal issues only.
I understand. Okay. And I'll reserve 3 minutes to for that.
All right. Thank you, sir. You may proceed.
Thank you. May it please the court. Good morning. I'm Harold Lippis. I represent the Appellate Cross Appellant David Roberts. One of the things that Roberts mentioned, and I mentioned in the cancer brief, was that we thought the appellant had misapprehended the judge's order. He's correct. We didn't, quote, preserve this issue for appeal. We didn't raise this issue for appeal. We didn't file this appeal. The appellant took this appeal. This was an issue that the trial judge raised on his own, as he said in the order, and accused himself, granted a new trial, quote, on his own, because he felt there was an appearance of impropriety, or whatever he felt, due to the conflict or perceived conflict, because of the bid on furniture factory in the courthouse. That ruling was entered, I think it's July 20, the court's order is July 22, 2011. The stipulation by the parties in the first day trial was in October of 2009. That we didn't have any problem with the judge proceeding with the case after he disclosed this potential conflict or perceived conflict. So more than a year and a half later, actually almost 20 months later, 21 months later, whatever it is, the judge enters an order and says, I'm uncomfortable with this. We need to do this again, and I need to recuse myself. And the case is remarkably similar to the Carlton case. And quoting from that decision, in that case, the trial judge heard the case, non-jury. 13 months later, he received a letter from one of the litigants who apparently forgot to, or inadvertently forgot to send a copy of his letter to the opposing lawyer. so it was an improper ex parte communication. The judge then entered a final judgment. Following entry of the final judgment, he granted a motion for new trial, and he said in his order that while he didn't think that he was influenced by this letter in any way whatsoever, that nevertheless, because of the appearance of impropriety, a new trial should be granted. And this court, in reviewing that order, said as follows: it is obviously difficult for a review court to test the conscience of a trial judge on a matter pertaining to improper communications. Here, although the judge felt he was not influenced by this communication, he did feel that it was necessary to grant a new trial and to recuse himself. We therefore affirm the order for a new trial and the order of recusal. We have the same situation here. There's really no difference. It's difficult or impossible for us as litigants or for you as the reviewing court to test the conscience of the trial judge and go behind his words and say, gee, what do you really think? Was there really a conflict? Was there really a legitimate reason?
Is it possible to distinguish the Carlton case on the basis that the appearance of impropriety here wasn't an improper ex parte communication, but rather a bidding process that was very public, that's very apparent from the record, that we could review and determine objectively whether or not there was an appearance of conflict?
I don't think so, in part because of the language in the Carlton case, which says that we really can't test the conscience of the trial judge. We, I think, have to give Judge Day the benefit of the doubt and presume that he would not have taken this measure, which is a pretty serious measure after all this time, without having done some soul searching and decided that he himself internally had some type of conflict. And so for that reason, I don't think it's distinguishable. I think it goes right back to the same standards where it's very difficult for us or for you to test the conscience of the trial judge.
So would you ascribe a broad holding to Carlton that in a case where there is an appearance of impropriety, that this court, there's a subjective portion to the judge's recusal, that we can't go behind that?
I guess each case has to be looked at individually, but in this case, I just don't think that you can. I don't think that there's anything there that would cause any of us to go behind his decision and say that there was something about that process that either was or wasn't a conflict. That was a conflict that he felt he had in deciding this case, and he felt it was serious enough to enter his order.
But my reading of the order was not that Judge Day searched his soul and found internal to himself a conflict. He over the passage of time and some of the issues with the courthouse, I got the feeling that he felt like that although he didn't see a conflict, that someone in the public or the public at large might perceive an apparent conflict. And in order to prevent that, he thought he should get off the case and it should be done over. So is there a difference? And are we in the situation where we can look at, all the facts out there in the world and determine whether the perceived appearance of impropriety that Judge Day thought might arise was founded or not well founded? Can we do that?
I think that the answer lies in the Carlton decision, where the trial judge said, and it was repeated in the opinion here, although the judge felt he was not influenced by this communication. So the trial judge in that case was in the exact same position as you just described Judge Day is in this case, where he doesn't feel that he did anything wrong or that he had a conflict, but that there was a perceived conflict, and it was serious enough in his mind for entry of the order, and therefore this order should be honored. And I think that's what the Carlton case is. That's one reason why the court's order should be affirmed. The second reason why the court's order should be affirmed is because the order, if you look at it in substance, is really an order granting a rehearing as opposed to an order granting a new trial. And I say that because this court went to extreme measures, actually, in the Pensacola Chrysler Plymouth versus Costa case to describe the difference between a rehearing and a new trial. And it's obviously a fine line. It can be a very fine line. But in that case, if you bear with me for a minute, the court stated, from the foregoing, it appears to us to be the intent and purpose of both the statute and the rule relating to motions for a new trial and motions for rehearing, that each is intended to serve a different purpose that is to be treated under different rules of law. The apparent purpose served by the statutory requirement and the provision of the rule that orders granting a new trial must state the grounds on which the order is based is for the purpose of preserving the integrity of a jury verdict and to permit it to be set aside only on specific and particular grounds, which must be set forth in the order granting a new trial. Thus, an appellate court, upon reviewing such an order, may make a more accurate appraisal of the trial court's action and ensure the sanctity of the jury's verdict, except when tainted by harmful error. Such factors are not involved in a judgment rendered in a court action without a jury. Under these circumstances, the trier of the fact is the best judge of whether he has committed error and whether that error is of such harmful nature as to require correction pursuant to a motion for rehearing. A motion for an order granting a new trial, coming as it does after the trial has been completed and the jury discharged, means that the case must be retried by a completely new jury before final disposition of the cause can be made. And then the court goes on to explain all the various things that can be done pursuant to a hearing, take additional evidence. It doesn't require a full new trial. We're in a situation where we're not going to have a full new trial. Just as an example, the issue regarding Robert's claim that Mr. Chappell improperly paid his personal legal fees from the company was resolved by the trial court. It's included in the judge's July 22, 2011 order. That issue's not going to be tried again. It's done. It's over. It's finished. Similarly, in the order, the judge states all the trial evidence will be admitted in the second trial. All the testimony, all the exhibits. So it won't be a situation where we have to completely reinvent the wheel and present all the facts and issues to the trial facts.
Well, you might not, but you'll have a successor judge just by nature of the judge's order, and the judge would have the power to revisit all those evidentiary rulings, I guess.
Certainly, but
I'm not suggesting that any judge would want to.
But that's true with the exception of the issue regarding the claim for payment of the attorney's fees. That issue is done and over with. They will not be retried. It just won't be presented. It's done. So in that sense, this is more like an order granting a rehearing than an order granting a new trial. And in the answer brief, in their answer brief on cross appeal, they didn't address this issue. All they did was say that the judge called in an order granting a new trial, that we called in an order granting a new trial, but they never addressed the substance of the order itself and the fact that this issue, for example, on the attorney's fees has been resolved, and therefore that we don't require an entire new trial, and therefore that this should fall substantively within the category of a motion for rehearing as opposed to a motion for an order granting a rehearing as opposed to an order granting a trial. Turning quickly to the cross appeal.
What order are you cross appealing? I had a little trouble following that.
The cross appealing the final judgment.
The final judgment. Okay.
And the basis for that
But
claim,
the final judgment is gone now because the judge granted a new trial.
which they appealed.
Which they appealed.
And so if you were to determine...
You're the appellee now defending an order granting a new trial. And I've always understood that a cross appeal had to be from some unfavorable aspect of the same order that was appealed. But you're going back now and you're challenging a previous judgment, which is no longer in effect. Is that right?
But if you were to reverse the trial judge's order, what they're asking...
It would be. Okay.
Then it would be.
I think I follow your logic. I'm not sure it's actually a cross appeal, but that's neither here nor there. Let's just wait for the merits of it.
And if you look, Your Honor, at the Pensacola, Chrysler, Plymouth cost case, they sort of address the question that you just asked and suggest that this is an issue that should be raised in this appeal. I don't know any other way to raise it other than a cross appeal.
I appreciate that.
So in the alternative, meaning in the event that you determine that the judge's July 22, 2011 order should be reversed, we would ask the court to then reverse the final judgment with remand the case back to the trial court for a new trial on the grounds that, A, there was this 14 or 15-month delay between the trial and entry of the judgment, which, stated in the brief and the cases that are cited therein, isn't grounds in by itself that justify a new trial. But those grounds, combined with something seriously amiss on the merits,
What you're saying in essence, and tell me if this seems right to you, is that the judge was correct to grant a new trial, but even if the judge was not correct to grant it for the reasons that he gave, he should have granted it based on the reasons you asserted in your motion for a new trial.
Correct.
Okay.
That's correct. And the best example that I think I can give is the issue that was described in the brief concerning the disparity of income. The parties had agreed in a shareholders agreement that their income would be commensurate with their ownership in the company. Their share ownership was 51%, 49% split. The evidence for the years that we had income for W-2 income showed that there was a disparity in excess of $300,000, and there was no defense of that claim. There was none. They tried to call it an unreserved claim. It was reserved. They tried to say it was pled. It was pled. They tried to say that Mr. Roberts didn't identify his deposition taken a month before trial, but the court granted a motion to compel discovery during the trial between the second and third days to produce these W-2 forms. Our motion asking him to enter that order said we want to open the evidence and include this claim. The W-2 forms were produced pursuant to the court's order. They were entered in evidence without objection, and the claim was presented. And there really was no defense to it. Thank you.
We call the cases distinguishable, as I distinguished in the brief, that there was actual improper ex parte communication and contact in violation of the Code of Judicial Conduct and the Code regulating the Florida Bar members. That's not our case. The Judge Day did not have a problem with entering a final judgment in 2011. He did have a hearing on April the 6th, and for a half hour announced from his own detailed findings of notes his rulings on all the issues raised in the bench trial over 3 days. And he entered a judgment on favor of the defendant on April 12, 2011. So at that point in time, he certainly was fine in doing that and recognizing that the bid on the furniture had not occurred. The cases that cited to the court in the briefs, the Hasagawa case, while the jurors were not particularly generous, nothing supports the finding that their verdict was irrational and not supported by the evidence, and they reversed granting a new trial in that case. Similarly, in the Harlan Bakeries case, the court says, while we recognize the broad discretion the trial court judge has in ruling on a motion for a new trial, we nevertheless conclude that reasonable persons could not differ as to the propriety of granting this motion for a new trial, and reversed the order granting a new trial in that case. In the TriPac case, they also reversed and concluded that the trial court abused its discretion in granting this new trial and remand for entry of a judgment in accordance with the jury's verdict. We're asking that this court be reversed and reinstate the final judgment for the defendant.
I'd like to ask you a question about the timeline. Is it your position then that after Judge Day entered the final judgment in April of 2011 that there had to be some conduct in the record or something that happened in the record for him to be able to grant this motion for a new trial on grounds that it would create the appearance of impropriety? Something had to have happened.
Something had to have happened or been articulated in the Rule 1.530F order. And I rely on this court's decision that counsel has brought to this court's attention, the Pensacola Chrysler case versus Costa, where we agree with Appleby's quote that orders granting a new trial must mandatory state the grounds on which the order is based for the purpose of preserving the integrity of a jury verdict for a final judgment in this case.
If we would agree with your position, would one possible remedy here be to reverse and allow the court to enter an order more clearly articulating the reasons for the recusal?
Yes, combined with what's happened between the April time frame when the final judgment was entered for a defendant to the July time frame, I submit that nothing has happened. He's been the model of integrity. He's conducted the trial proceedings with cold neutrality and with the utmost honor and respect. And I'm very comfortable with that occurring. If I could have a few moments to try to address the cross appeal. This is not a motion for rehearing. The evidence is clear that out of an abundance of caution, a new trial is warranted is what the judge ordered. And so I'm not going to spend any more time on that. This is a purely legal question for this court to decide whether another Duval Circuit judge not directly involved with making recommendations to the chief judge would be, quote, better suited to retry this case. And whether that is something we want to put cost on the litigants to have to retrial after having a good, fair trial in the record. Appleby has failed to show the trial court's work on the new courthouse project that was fully disclosed and resulted in a palpable miscarriage of justice. And when the court entered final judgment for the appellant Chappell, participation with the new courthouse was a collateral matter that had nothing to do with...
Counsel, your time has expired.
I assume my time has expired too, because I don't think you addressed the issue of cost.
No, that's correct. Your response would have been limited to that. But I think if it's any concern to either of you, I think we fully understand your arguments on both sides. So with that, we'll call the next case.